All right, y'all. Let me let y'all know what's going on. Real deal. The YSL trial judge to determine if the rap lyrics can be used as evidence in Young Thug's case. Okay. Should the rapper's lyrics be used against them as evidence in court? That's the question that was posed to Fulton County Superior Court Judge Uriel Glanville in the case against rapper Young Thug. Other defendants accused of participating in a criminal street gang responsible for violent crimes. YSL, which prosecutors say stands for Young Slum Life Gang was confounded by Young Thug, whose given name is Jeffrey Lamar Williams. He said it stands for Young Stoner Life Records. That label has featured several big acts, including Young Thug and Ghana, who were both initially indicted on charges related to gang activities. Okay, but prosecutors say YSL also stands for Young Slime Life, which they allege is an Atlanta based violent street gang affiliated with the National Blood Gang and founded by Young Thug and two others in 2012. Prosecutors said people named in the indictment are responsible for violence crimes, including killing, shooting, and carjacking to collect money for the gang, burnish its reputation, and expand its power and territory. Hmm. As a part of their argument, Fulton County District Attorney Fannie Willis and her office argued that the rap lyrics in the tracks released by the artist on the label are evidence of crimes committed by the gang, saying that the lyrics are highly pertinent to the defendant's state of mind and intent. Defense attorney in the YSL RICO trial plans to have several experts testify that the rap lyrics are negatively interpreted by most Americans because of racial bias. There's a strong legal test of when a lyric can be used as evidence. Georgia State College of Law professional Moat Ivory said lawyers for Young Thug have an expert who has done extensive research on race and criminal justice system to testify. Prosecutors have called the defendant's argument against using lyrics ridiculous and went as far as making references to the bomber Ted Kaczynski and Sikai Timothy McVeigh. Documents reveal prosecutor has spent 9 years scouring the music and social media posts of Young Smile Life members, but they also say they have additional evidence against Young Thug and his co-defendants. Prosecutor also, um, hold on, y'all. Prosecutors also had no doubt scoured through the lyrics of Young Thug's latest album, Business is Business, which were released back in June, despite the rapper being held in the Fulton County Jail. Was does the YSL RICO case stand for? The YSL RICO stands for Young Thug, whose legal name is Jeffrey Lamar Williams, has pleaded not guilty to charges of conspiracy to violate Georgia RICO Act and participate in a criminal street gang. Okay, so I'm not going to get into what happened last December with rapper Ghana, okay, whose legal name is Sergio Kitchens, walked out of the Fulton County Jail after taking a plea deal. Attorney for the Ghana said that Kitchen, in exchange for a guilty plea, would not serve any time in prison. The plea deal sentenced him to 5 years with 1 year to serve in prison. That time was commuted to time served, and the balance was suspended. He would need to complete 500 hours of community service, with 350 of those hours speaking to young men and women in the community about the dangers of gangs and gang violence. The YSL RICO trial has dragged on for 10 months at the Fulton County Courthouse. Getting a jury seated has been the main holdup, but now we do have the jury seated. Okay, so let's get into this video. Okay, let's get into the lyric motion hearing for Young Thug, as known as YSL Slime. Thanks for watching, and don't forget to smash the like button if you have not subscribed. Please do. And if you'd like to donate to the channel, please donate to the super chat. I really appreciate it. Okay. Thank you so much.
Difference, Your Honor, between an abstract musical expression or any other kind of artistic expression that can't be linked to the charges and the behaviors accused in an indictment. So looking at that in a vacuum is exactly what should not, and then trying to conflate it with the facts of a case like this or any of the other cases where this has been done is just not the analysis involved. Another insightful line, Your Honor, this time from the Eastern District of New York. The defendants have to find an evidence rule to keep relevant evidence out. And there's no exception for art in the federal rules of evidence. Perhaps that's why the request to you is essentially to create a rule in this case, which is obviously not what the structure of our government allows. So we see this is not a situation where the rules of evidence can be suspended. Right here, to the court's question from a moment ago, the defendant may argue he took certain creative licenses, but that goes to the weight of the evidence, not its admissibility. A jury issue, Judge. Was this true? How true was it? If it moves the needle of relevance, then it's presumptively admissible, and that's what cross-examination, opening statements, and final arguments are all about. And let's take a look at the genre-specific issue, Judge. The same rules that the state is relying on to introduce the lyric evidence here has been used across the country in hate crime and hate group prosecution to get in the material that they inundate themselves with. This United States v. Canada is an example of that. Speech-based evidence to support a finding that the crime was motivated by racial hatred. Again, Your Honor, we are asking for the same rules to apply here as they would anywhere else. And that's not to say there's a moral equivalency between the gang lyrics in this case and hate lyrics in some other prosecution. But there is a legal equivalency, Your Honor, between might say that this becomes admissible. So, Your Honor, there's no First Amendment bar to the use of the YSL gang lyrics as evidence of YSL crimes. That's not something that's constitutionally prescribed. And we see here over to the right of this slide in our first lyric brief, supplemental lyric brief, and second supplemental lyric brief, extensive authority from Georgia, from federal courts, state courts all around the country that really are in unison on this. So now we go to the next issue, Your Honor, whether or not gang lyric evidence can be used to, or how, because we know it can be used to prove criminal intent or a criminal act. Now we have this case from our Court of Appeals that says right there, both this court and our Supreme Court have held that a trial court does not abuse its discretion in admitting evidence when a defendant's written lyrics, when that evidence is relevant to some issue in the case. Not every issue, not all issues, some issue. Is there one element of proof that somehow this lyric evidence is going to make more or less likely have occurred? That's the test before the court, according to our Court of Appeals in Ward versus State, 339 Georgia Appeal 621, 339 Georgia Appeal 621, and quite frankly, Your Honor, we are not going to isolate it to one. So we see those two rules that now apply. Our Rule 401, liberal relevant standard, set forth there in Booth versus State, and then Rule 402, the cornerstone rule of our evidence code that says all relevant evidence shall be admissible except as limited by constitutional requirements which don't apply here or is otherwise provided by law. Now, Your Honor, Rule 402 has been actively used by our Supreme Court to take away former common law restrictions to the introduction of relevant evidence, but also to preclude exactly what the defense is asking for here: judicially protected rules of exclusion. And that is what the defense is asking. Call it art, keep it out, ignore the work of the General Assembly. So we go forward, Your Honor, as we head into this now, relevance is determined by the elements of the offenses. As to both actus reus and mens rea, we have these two areas now are not controlled by the Constitution. These two areas. So we're going to look at the elements of those offenses. Floyd is here to assist us with that when it comes to the racketeering laws, and I'm going to survey this in any number of areas quickly prior to the Deputy District Attorney Hilton providing us with the specifics of this case. So, Your Honor, in a criminal street gang primary charging provisions, that's 16-15-4A, there are four matters the state needs to prove, according to our Supreme Court. So what we need to think about now is does the lyric somehow make more or less likely one of these four matters? So does it demonstrate that an underlying offense occurred? Does it demonstrate that the group in question is a criminal street gang? Does it demonstrate that the defendant is associated with a criminal street gang? Or does it demonstrate that the defendant participated in the gang through the commission of the predicate offense? That's what the statute says. So, and remember, the grouping and are those criminal in nature. And this is used in front of the Supreme Court, essentially, Judge, to demonstrate how this 1615-4A statute works. So does in this case, lyric evidence somehow show that the defendant, the person there, is associated with the gang? Well, we're going to have plenty of this.